All right, welcome to all. We're happy that you're able to join us today for our topic, Intellectual Property Strategy is a Business Strategy. My name is Paula Whittigand. I am the Arizona Network Small Business Development Center Training Manager. I'll be hosting today along with Esmeralda Estrada, and she will also be hosting. She's a program coordinator at the SBDC State Office. So today we are going to take a look at and learn why intellectual property strategy is important to your business, whether you're just starting out, just very pre-venture early stages, or maybe you're that established business looking to grow. Intellectual property is an important topic to be aware of as you're looking at starting and growing your business. And our guest facilitators today from the USPTO are going to take you through all of the details of what you need to know to get you started down this path. So let's see, just a reminder again, if you do have questions, please make sure you put them in the Q&A. And as we're moving through each of the different content sections, we'll address those questions as appropriate. So our facilitators, and just to kind of give you an overview, is we're going to be looking at trademarks, patents, trade secrets. We're going to be talking about copyrights. And along the way, we're going to be sharing resources, not only from the USPTO, but local resources that we have here in the state of Arizona. Now, before we jump in and I turn it over to our guest facilitators, some of you may already be familiar with the Small Business Development Center Network. Some of you may be new to SBDC. So just very briefly, the Small Business Development Center, we are here to provide assistance to small businesses. We offer confidential one-on-one, no-fee counseling to our small business clients in a variety of different areas: business plan development, strategy. Maybe you're looking for capital. We help our clients prepare to get lender ready and find the capital appropriate for their needs. Financial education, marketing, export assistance, government contracting, you kind of name it. We have experts in our Arizona network that help our small businesses, but we're also a national network. So some of you might be joining us from outside of Arizona, and just know that the SBDC, the Small Business Development Center Network, is a national network. So there will be SBDC resources most likely close to where you are located. And at the very end of the presentation, I'll share more about how you can get access and request counseling if that's something that you are interested in. So with that, I would like to introduce our guest speakers from the United States Patent and Trade Office. Wade Miles is the primary patent examiner and assistant outreach coordinator from the USPTO. He's going to take us through our trademarks and patents and trade secrets. Andrew Moore is an attorney advisor with the USPTO. He's our copyright expert, and he's going to be sharing that information with you. And then Emma Stoltenberg is the lead reference librarian and patent trademark lead representative for the state of Arizona Research Library. So she's going to have some really great resources to share with you today towards the end of our presentation. All right, and with that, we're going to get started. So let's see, Wade, I'm going to turn it over to you. Wade's going to take us through patents, trademarks, trade secrets.
How's everyone doing this morning? Thank you for being with us today for today's presentation on intellectual property as a business strategy. If you have any questions, feel free to type them into the Q&A box, and I will stop a few times throughout the presentation to answer questions. As I said, my name is Wade Miles. I'm a primary examiner at the USPTO. I'm in TC 3700 and examine medical devices. So if it's a mechanical tool that's used to help save lives, it may come across my desk. Later we'll have Andrew Moore talking to you guys about copyrights, and Emma Stoltenberg will talk to you about our PTRC program. And I'm going to talk to you guys about trademarks, trade secrets, and patents. Just a reminder that all the material presented today is for informational purposes only and is not considered to be legal advice. You will want to consult with the appropriate sources for legal authority and guidance if you have any legal questions relating to today's presentation. So let's start from the beginning. The patent system was written into the Constitution during the founding of the United States. In the U.S. Constitution, Article 1, Section 8, Clause 8, the Founding Fathers granted Congress the power to create a patent system that would promote and progress the science and useful arts by securing a limited times to authors and inventors the exclusive right to their respective writings and discoveries. This clause is also the basis of the U.S. copyright system, and today we consider the term useful arts to be referring to the technology. Here you can see just a little bit of a comparison between IP-intensive industries and non-IP-intensive industries. As you can see, in IP-intensive industries, there's a pretty clear edge here. This was a study conducted by the USPTO in 2019, so the numbers are a few years old, but they're pretty recent and still very applicable. As we can see, like the IP-intensive industries the employees tend to make more money per week. They tend to be larger companies. The employees tend to receive better benefits, and the employees tend to be more highly educated employees. This slide, it's another slide just kind of showing some benefits of IP in the US economy. As you can see, there are 63 million jobs in IP-intensive industries, so almost 45% of US jobs are IP-intensive. IP-intensive industries are responsible for nearly 50% of the US GDP. Again, we talk about the amount employees make per week is greater in IP-intensive industries. So IP strategy is a business strategy. There's a few reasons that an entrepreneur and a small business owner should consider if and how IP should be a part of their business strategy. I'm sure many of you are familiar with the show Shark Tank. Often one of the first questions that's being asked by the investors or the sharks is they ask if the entrepreneurs own any IP. And the reason they ask that, there's a lot of reasons. Owning IP in general will give you an edge over your competitors who may not protect their IP. So why is it giving you that edge? IP can be a deterrent for competitors in the marketplace. So if you've put your technology out there, other competitors see what you have now created, and they may have to alter their plans in order to not infringe on your invention. IP protection also allows the owner of the IP to enforce their IP protection if they're being infringed upon. So if you receive a patent on an invention, a competitor then infringes on your patent and puts a product on the market, you have the IP protection and a tool to go after them for infringing on your patent. So the last few slides also showed you a lot of numbers, and in general, I think the message is that IP-intensive industries have a great economic benefit, both for the economy as a whole and for the individual employees who receive higher pay and better benefits. IP rights also add value to the businesses. When it comes time to sell the business, the IP can also be sold as an asset or licensed out as an asset. IP can also be used as leverage, such as when a business is obtaining a loan. If you have that IP can be used as part of your portfolio to leverage that loan. Finally, IP will provide a good entry into global markets. Though you do want to keep in mind that intellectual property rights are territorial. So they are, each country governs their own IP rights, and they vary depending on where you are filing. So generally, though, as you can see, there are many benefits to developing and implementing an IP strategy. And ultimately, it all culminates in IP making your business more attractive to potential investors and buyers. So let's do just a little brief mock IP strategy development. So your first step here is that you'll want to access your company's IP assets and prioritize which technologies benefit your company in the short term, medium term, and long term. Next thing you'll want to do, you need to know your competitors. So you'll want to research what they are working on. For instance, if your medium-term technology is already being developed by a competitor and they're in the marketplace and they're filing IP, it may be better to shift your focus towards some of your shorter-term or longer-term IP assets. For example, let's say your medium-term asset is to develop a better focusing lens for your VR device, a virtual reality device, by adjusting the lens within the device. But you've noticed your competitor is filing patents on similar technology that you're developing. So at that point, it may be worthwhile to take a look and focus on maybe some short-term assets, like maybe an eye tracking device used in VR. Or even shift to a longer-term asset, such as liquid lens used in VR devices. So the third step in IP, developing an IP strategy, what is the pace of innovation by your competitors in your own business and in the industry at large? Based on that determination, maybe you can find some gaps and opportunities for growth in your business, find the inequalities in the marketplace, so to speak. Now that you've determined which technologies to focus on, determine the best way to protect your IP. With IP, there are 4 categories of protection. We have trademarks, patents, trade secrets, and copyrights. We're going to discuss each of those in a little more detail throughout today's presentation. So now it's time to develop a plan. You want to set your goals and implement your plan to achieve the goals you're setting. And finally, if you do hit a roadblock, get help. The USPTO is here. We have a lot of resources. We can always point you in the right direction towards more resources that we're providing. There's always the option of hiring an IP legal counsel to also help you navigate things. So as I mentioned, there are 4 types of IP. We have patents, trademarks, copyrights, and trade secrets. First up, we have patents. A patent is a exclusive right granted for an invention, which is a product or process that provides, in general, a new way of doing something or offers a new technology or new technical solution to a problem. So next we have trademarks. Trademarks or service marks give legal protection for a brand. So you're thinking about brand names, logos, slogans, things like that. It's what we use every day as a consumer to identify the products and services we are using and purchasing. For instance, if you have on a shirt, you might have a logo of the shirt maker on your chest or on the sleeve. Those are often going to be trademark logos of the branding. USPTO handles the filings for both patents and trademarks for the US only. And then we have copyrights. Copyrights are actually handled in the Copyright Office, located in the Library of Congress. And a copyright is a legal protection of an original artistic or literary creation. So in this case, we're talking about songs, movies, books, sculptures, paintings, photographs, software, things like that. Any kind of creative expression and then placed in a tangible medium can be filed as a copyright. So Andrew Moore is going to talk to you guys later about copyrights and give you a lot more detail. So looking forward to that. And we have our trade secrets. Trade secrets are protect information that has value because nobody knows what it is. Often the value is keeping that secret and limiting that information to only a handful of employees. Usually it's often something like a recipe. Here you see like Coca-Cola and whoops, and I am sorry, I forgot to slip over slides. But here you can see Coca-Cola and KFC. Those are both brands we all recognize, but those trade secrets those are generally going to be recipes, and we have the Coca-Cola recipe. Has tried to be replicated for many years, and it's been failed by competitors that failed to do so. We also have KFC, the 11 herbs and spices that go into their fried chicken. So those are examples of trade secrets. Right. So now we're going to talk about trademarks. We're going to talk about that first. So what are trademarks and service marks? They can be symbols or pictures. So think of something like a Nike swoosh. They can also be phrases, words, or slogans. So not only is Nike as a brand trademark, but Nike has the phrase or slogan, "Just do it," also trademark. And then we also have plenty of non-traditional trademarks, things like colors, smells, trade dress, and we'll discuss those in a little more detail also. So we'll start off here with some of the more obvious ones. What are trademarks and service marks? Anytime you see a particular trademark, it should be something that calls to mind a particular sets of good or services. It immediately identifies the brand in mind of the consumer. As you can see here, we have several different trademarks. I think most of these are recognizable to most of us, even if they do not include the name. So a trademark is going to help that consumer distinguish the product. For instance, if you're driving down the highway and you're looking to grab a quick bite to eat, if you see the golden arches, you're coming up on a McDonald's. It helps you distinguish between a McDonald's or, say, like a Burger King. So that's the importance of branding and trademarking your brand. Another option, when you see the Apple logo here in the top right, you're always thinking of computers, you think of cell phones, you're thinking of watches, earbuds. Again, when you see that, what comes to mind are all those industries, across several industries. It's not limited to just the one. Again, with McDonald's, you see that. What do you think of? You're thinking of hamburgers. You're thinking of drive-through food restaurants. Some other options when you think of when you see the Mercedes symbol, you're thinking of cars. So I think y'all are getting the idea here. On the right, you also notice we have TM, SM, and the Circle R logo. You've probably seen at least one, if not all of those before. Usually they'll be next to a brand name or a logo or a slogan. But maybe you don't know exactly what they mean. I think, when you see TM, I think it's fairly clear that probably stands for trademark, and it does. However, it specifically is referring to an unregistered or pending trademark. The Circle R on the far right, that is the symbol that is used once a trademark has been officially registered with the USPTO. So when you file that trademark application and you receive your trademark, you can transition from using the TM to the Circle R logo next to your branding. We also have SM, which is sometimes used for service providers. Think of like legal services or banking, rather than providing a good, like a computer or food or cars. SM's service marks can also be used. The SM symbol can be used for a service mark that has not been registered with the USPTO. So it's used in a similar manner as the TM for trademark. So as you can see here, this is a list of the top 40 brands, global brands, in 2023. There's a firm called Interbrand that uses their own algorithm to perform brand valuations every year. They factor in a company's economic profit, the role of the brand made in marketing and purchasing decisions, the strength of the brand against competitors, and ultimately derive a value for that brand. As you can see here, that the Apple for Apple is the Apple logo might be the most valuable, or is considered to be the most valuable brand in the world, even significantly more than Microsoft. However, if you go down this list, I think you probably recognize most, if not all, of these logos and brands. These are all some of the biggest brands in the world. I think we're all fairly familiar with. So trademark rights. Trademark rights can be derived in two ways. First, there's the common law trademark right. Under common law, as soon as you start using a name or a logo, that is your trademark to indicate your source of good or services. However, there are some limits. Typically, there are state laws that do govern common law trademark. And common law seems like, it seems like maybe a great way to, trademark your logo, but without having to go through a filing process and paying filing fees. However, under common law, your trademark rights are going to be limited in a more geographic area in which your trademark is used. For instance, if someone opens a food truck in Phoenix and they are only operating the food truck in the Phoenix area, then they will have a common law trademark on their name and logo for the Phoenix area. And the truck can use the TM logo next to their name, or the TM symbol next to their name or logo to indicate that that is their trademark, but it is unregistered. However, if you want a more national coverage, then you would want to file with the USPTO through our trademark registration process. And again, once that trademark is issued, you can use the circle R symbol next to your logo. So what are the advantages to registering your trademark with the USPTO instead of relying on common law trademark rights? So if you own a growing business and you're hoping to expand your business outside of, say, Phoenix or say, the state of Arizona, then you may want to consider registering your trademark at the USPTO. The reasons is that it will provide a nationwide trademark protection for your logo or your brand name. It'll put the public on notice that you own that trademark and provide the business owner with the right to use the mark associated with the class of goods nationwide. It will also allow the owner to register their trademark with the U.S. Customs and Border Protection, which allows customs to monitor for and seize counterfeit goods infringing on your trademark when they enter the country. Additionally, the trademark will be listed in the USPTO database, and as discussed, the owner can begin using the Circle R logo next to or Circle R symbol next to their logos and trademarks. So, what are some examples of trademarks? The ones that are easy, the ones that we know are the words and designs that we see here. We have trademark words such as Starbucks, Nike, Target. Generally, words that are trademarked for a name of a business usually do not have anything to do with what that business actually does. For instance, Starbucks as a word has nothing really to do with coffee. Nike as a word has nothing really to do with tennis shoes or athletic apparel. Another thing is we have trademarks as designs. Those are your logos that you often see used in branding. Here we have the Starbucks siren, we have the Nike swoosh, we have the Target bullseye. These are all very well-known logos that we see around almost every day. So what are some non-traditional marks? Non-traditional marks include things that aren't words and logos. So a trademark can be anything that does indicate the source of a good, and that may include the color. For instance, on the left, that box is a robin's egg blue box used for packaging jewelry. And that blue color is registered specifically to Tiffany's, so that whenever you see that box, you know that it is a jewelry item from Tiffany's. In the middle, we see the UPS truck. We all get packages from that truck. We see it around our neighborhoods. So how do we know it's a UPS truck at first glance without even seeing the UPS logo? We recognize the brown color. So UPS actually has that shade of brown that is used in their trucks and in their uniforms trademark. On the right, we have the John Deere lawnmower. Similarly, John Deere has trademarked that green and yellow color scheme. Now, keep in mind that trademarking a color is trademarking a specific shade of that color. It does not cover every shade of brown or green or light blue. So it is fairly limiting when it comes to the shade of color, but that shade is very important to these brands. More non-traditional marks include scents. For instance, if you walk into a Verizon store, you might notice a particular smell. Verizon has actually trademarked the aroma they use in their stores, and every single Verizon store uses that same scent, so that when you walk in the door, every store will smell the same. There's also Play-Doh. Hasbro has a trademark on the fragrance found in Play-Doh. We also have Manhattan oil, which makes like a scented automobile oil that will give a car exhaust a different smell. They have here we have a groovy grape. I believe there's strawberry and several other smells out there. And then finally, we have sounds. Sounds can also be trademarked. Those include like the Pillsbury Doughboy giggle, the NBC chime, the sound of the coin in Mario when Mario hits the box to get a coin. Some others not listed here include like the Aflac duck saying Aflac, or the MGM line roar. And so finally, we also have trade dress. What is a trade dress? Trade dress is similar to trademarks in that it does identify the goods, identify the source of the goods based on the look and feel. Some examples here on the top left, we have like a Doc Martin boot. Doc Martin boots have a couple of specific distinctive features, such as the yellow stitching, the sole patterns, the Doc Martin black heel loop. So those are part of their trade dress. Here in the top right, you see a Hershey Kiss. When you see this packaging, you know immediately it's a Hershey's Kiss without having to taste the chocolate. Why do you know that? You know because of the twisted foil wrapping and the Kisses paper tab that is hanging from the top of the packaging. Bottom right, we have the Coca-Cola bottle. It has like specific design of ridges that identify it as a Coca-Cola bottle, irrespective of its functionality. And then finally, in the bottom left, we see an Apple store. Trade dress can include store designs. Basically, every Apple store will look very similar. The interior design layout will help identify it as an Apple store, as well as the Apple logo itself. So store layout is also considered to be a trade dress. So how much does it cost to file a trademark? The cost to obtain a trademark will depend on whether you're filing under a T's Plus or T's Standard option. Under a T's Standard, you'll pay $350 per class of goods per trademark. And under T's Plus, you will pay $250 per class of goods or services per trademark. The advantages of T's Plus is that you may enter your class of goods upon filing, which makes things more efficient and will help your trademark move through the process faster. However, you are limited to pre-approved classes of goods as listed by the USPTO Trademark ID Manual. In most cases, these classes of goods are not too limiting for the filer, and ultimately filing under T's Plus will save the filer time and money. So you're probably thinking, T's Plus sounds good. But what are these classes of goods? Classes of goods is just kind of the industry in which your business is operating. For instance, we have the classes do not have to overlap, and there may be separate trademarks owned by separate trademark owners in different classes that are similar or the same. For instance, we have Dove soap and Dove chocolate. Both share the Dove name, but they are not considered to be the same class of goods, and so there is no trademark infringement. Similarly, we have Delta Airlines, and then we have Delta Faucets. Again, no trademark infringement because these are two totally different classes of goods. So we also mentioned earlier about, say, like Apple, and Apple is a company that is involved across multiple classes of goods, such as computers, cell phones, watches, earbuds. So how do they get trademark coverage in each of those? Essentially, when Apple would file their trademark, they would simply file that trademark for each of those classes. And so their fees would add up and would end up being $250 per class. So if they registered in 4 classes, that would be $1,000. So now let's talk about trade secrets. This one's pretty short and sweet. Let's see. So as you can see here, we have, we mentioned these earlier. These are 2 of the most famous trade secrets out there. We have the Coca-Cola recipe for the original Coca-Cola. That recipe is only known to a handful of Coca-Cola employees, and the competitors for years have tried to replicate it, but have failed. So we end up with other soft drink brands out there with different tastes, such as Pepsi or RC Cola. Again, we have the KFC's unique blend of 11 herbs and spices used in their fried chicken batter. Many have tried to replicate that recipe, but have never been able to perfect it. So what are some other options, though, besides recipes that may be considered for a trade secret? Maybe a law firm or a consulting firm would consider a client list to be a trade secret. There's also algorithms considered to be trade secrets, such as the Google search algorithm. At least the core of that algorithm is a trade secret and has not been released by Google or not been disclosed by Google. So when should you decide, or when should you use trade secrets as part of your IP strategy? So when you are considering a trade secret, you want to consider, what is this information? The information has value because nobody else knows it. No one else knows the Coca-Cola recipe. No one else knows the KFC recipe. And so there's no way there's no incentive for the trade secret owner to disclose that recipe. There's also no way to really reliably reverse engineer a recipe. Perhaps you can produce a soft drink that tastes similar to Coke, but it may not taste exactly like Coke. And there's no way to know that you have perfected that recipe without the knowledge of that recipe. Generally, trade secrets are maintained within the company confines. They're protected by signed agreements between employees and companies. often requiring non-disclosure of proprietary information and non-competition clauses. This falls within the level of reasonable effort to maintain a secrecy by the company. And let's see, the common ways that a company does lose their trade secret is failing to take those adequate steps to prevent disclosure. So say a company, say Coca-Cola is leaving their recipe just laying out on a conference table in headquarters, and anyone that walks by can see that recipe. Perhaps that's failure to take an adequate step to prevent disclosure. There is no way to prevent reverse engineering also. That's why with more mechanical technologies, trade secret is not really that valuable because we can start taking apart a device and understand how it works. And then finally, there's no way to protect against independent development. If you started a soda company today and you managed to recreate a drink that tastes exactly like Coca-Cola, Coca-Cola cannot do anything to you. So we have the Defend Trade Secrets Act of 2016 that does allow the trade secret owner to sue in federal court when a trade secret has been misappropriated. Those would be situations such as a former employee leaving a company and then spilling the beans to the competitors. I will stop here for a moment and see if we have any questions on trademarks or trade secrets, and then I will proceed to patents.
Right, thank you, Wade. We do have quite a few questions. So someone recently got a trademark. How long does a trademark last? And then what happens if they forget to renew or refile it? And then if they do miss the opportunity to refile it, how extensive of a process is it to get it back?
So with a trademark will remain good as long as it is in use. So if a business owner files a trademark for their business logo, as long as that business is still in business, the trademark will still be protected. Now a trademark lifespan, they can last forever. And like I said, as long as they're continued to be in use, I think you should be fine. If for whatever reason, the business is no longer functioning, then maybe there is some trademark lapse there. But I am not entirely positive how to maybe reactivate that trademark because I'm not a trademark expert, unfortunately.
Thank you. There's another question about how to register a trademark. Is there maybe like a resource that you could provide?
Yeah, I will put up some slides later that include some resources. If you go to our USPTO trademark website, we do have some YouTube tutorials linked there that will walk you through the trademark filing process. You can pull up the tutorial on your phone or on a screen and then have your actual trademark application on the other screen or on another computer and walk yourself through that process.
All right, thank you. We actually have a few about like international IP. Do you have to get your IP in every country that you're selling your products? Like if you're selling it in another country, do you need the IP in that specific country as well?
IP is a territorial, it's territorial, so your US filing is only covering your US protection. Any country that you are expanding into, you'll need to do research into their specific IP laws to understand how to navigate that.
Awesome, thank you so much. All right. And then if you only want to register your trademark locally or like within Arizona, for example, is there a specific place that you register with?
No, there's only the USPTO national registry. There's no state specific or regional specific trademark registry.
Awesome, thank you. And then there's a few questions about this specific one. So to file a trademark, is it can you file multiple trademarks for like a word, a symbol, and a color? Or is it just like one application for all of those?
It would be a separate application for each trademark. So, you know, for using Nike as an example, Nike as a term would be a trademark. The swoosh would be a trademark, and then Just Do It would be a trademark.
Awesome. So each one, like each item would have its own fee, like the $250 fee.
Yes.
Awesome, thank you. Let's see what other questions. And then there was another question about the fee. Is it a one-time fee or is it annual, or does it continue? Do you continue having more fees?
Trademark fees are a one-time fee. So you pay that up front and your trademark is registered.
All right, thank you. I think we've answered. Okay, and then we're gonna tie back to.
And actually, I will say, there is a renewal with the USPTO after 10 years that will need to that you'll need to be aware of if you're continuing to use your trademark.
So like if they're still in business, what someone asked that question about what do you mean by still in business? Is it an active business structure with no clients, or what would that active business refer to?
Active business would be, you know, you don't necessarily have to be selling a product at that moment, but you do need to be in the function of running a business and planning your business, planning to sell your products or your services. You know, it doesn't, you can't register a trademark and then simply hold that trademark without taking steps towards creating the business.
All right, thank you so much. So those are the questions that we had for trademark. The other ones we could wait until after you cover those topics.
Okay.
Thank you, Wade.
So now we will talk about patents. This is where I am more of an expert. So, so what is a patent? U.S. patent is a property right granted by the U.S. government to an inventor that gives the right to exclude others from making, using, offering for sale, or selling invention throughout the U.S. or importing the invention into the U.S. during your patent term. Patents are territorial. There's no such thing as a worldwide patent, you know, as we already brought up. So there's three different types of patents. The most common is a utility patent. This is the most overwhelming majority that we receive at the USPTO. Utility patents cover new and useful processes, machines, articles of manufacture, and compositions of matter. The second most common type of patent is a design patent. Design patent protects the way something looks, but does not cover that functionality. So it's purely an ornamental design. And then we finally have plant patents. These are the least common types of patents. They cover new and distinct, invented or discovered asexually reproduced plants. We also mentioned about patent terms. A patent term for utility and plant patents is 20 years from the date of filing, whereas the patent term for a design patent is 15 years from the date of issue or grant. So here we have the top 15 patent classifications for Arizona inventors. This is information pulled from the last 3 years, so going back to March 2021. As you can see, some of those on the right are a little bit harder to read, but we have semiconductors and then digital data processing way out, kind of taking up a lot of this. But then we get pretty diverse. There's quite a lot of medical device technology being developed here, which are devices that may come across my desk as an examiner. So here too, you see patent types by Arizona inventors. I mentioned how utility patents are the overwhelming majority. I think this pie chart clearly shows that. In the past 3 years, there's been 12,787 patents issued to by the USPTO to Arizona inventors. Almost 12,000 of those are utility patents. Just under 1,000 of them are design patents, and then only 15 out of 12,787 are plant patents. So why should an inventor disclose their invention to the world? The underlying basis for the patent right is kind of a simple quid pro quo. In exchange for a detailed description of the claimed invention, including how to make and use it, the inventor can receive a time-limited exclusive right to practice that invention. How does that benefit the people? Well, it incentivizes disclosure of the inventions, which increases dissemination of new ideas, which is a societal benefit because it leads to further innovation and technological advances built on that technology to create a better future. It's important for young innovators to know that applying for a patent is not about hoarding one's ideas. It's about allowing inventors to share their ideas while also protecting their novel work. That way they can provide kind of a stepping stone for the next innovator to improve upon their ideas. So if we think about it, for instance, like a chair, we have the original inventor creates a chair, has a seat, a back, and 4 legs. Subsequently, another inventor comes along and invents a rocking chair by attaching the curved rocking legs on the bottom of the 4 leg chairs. So in this case, you would have the original chair would be the original invention, but someone was able to take that idea and add the rocking legs to the rocking chair. So therefore, they improved the original invention. Oftentimes, patents are fairly incremental advances. They aren't necessarily, you don't have a patent on like just a computer and then no one else. It's a lot more nuanced than that. So when should you file a patent application? You want to keep in mind that the US is a first inventor to file system. So you want to identify your IP early and begin the patent filing process. The first rule of patent application planning is to plan to file your patent applications with the USPTO prior to making public disclosures, public uses, or offering the technology for sale. If you do make a public disclosure or public use or offer that technology for sale, all is not lost in the US. The US will allow you to still file a patent application within 1 year of that public disclosure, use, or offer for sale. However, if you're interested in pursuing international protection, many international countries prohibit filing for protection after any disclosure. So the best rule of thumb is to get in a habit of identifying your IP and begin that patent filing process in the US and any other countries in which you want to seek protection prior to public disclosure, public use, or offering it for sale. One reminder is that we do have a provisional patent application that can be filed more quickly and cheaply than a non-provisional patent application. The provisional patent application will hold your filing date for 1 year. So again, I mentioned we have a first inventor to file system. So filing that provisional patent application to hold that date can be very important. You'll need to decide within that 1 year whether you wish to pursue a more formal non-provisional patent application or not, and begin working on that process and get that on file within 1 year of the provisional. As I said, the provisional then that allows the inventor to be the first to file a potentially patentable invention while still developing the product and determining their next steps. So what are some risks of disclosure? From a legal standpoint, it makes sense to file a patent application as soon as possible. As I mentioned in the last slide, the US is a first to file system, first inventor to file system. So you want to make sure that you are staking your claim to your patentable technology early. We recommend filing patent applications prior to pitching ideas to investors, preventing inventions at trade shows, publishing research papers on the invention, posting info on the internet, providing a description to a newspaper, magazine, or journal article. Really almost anything where you're going to be talking about your invention outside of your research team or your business team. You want to be careful there. Once you've made that public disclosure or public use or offer for sale, you're now forfeiting patent rights. So keep that in mind. But how do you go about getting funding if you aren't supposed to tell anyone what you're working on? Well, in that case, you want to protect your ideas from being stolen using non-disclosure agreements. And also, as I mentioned before, there's the option of filing provisional patent applications to establish a first to file filing date. And I'm sorry, I forgot to flip over the slides on Esmeralda's side, but here's the risk of disclosures. And then here is our patent fees. So here are the fees for utility patents, at least. As you can see, a provisional filing fee is much cheaper. And then if you qualify as a small entity, it's about a 60% discount. And then if you qualify as a micro entity, it's even a greater discount. So initial cost for filing, if you file that provisional, that initial cost is pretty low. And then you have your transition to a non-provisional application. That cost will cost anywhere from about $364 for a micro entity up to over $1,800 for a large entity. Now, keep in mind, these are purely the USPTO fees and do not include attorney fees or any international filing fees. These are also not the extent of the USPTO fees. There are a lot of other fees for things like excess of 20 claims, excess of 3 independent claims, late responses, things like that. But we do have a full schedule of the fees on our website. I will stop here now. I am finished up with patents. Do we have any questions before we move on to copyrights and Andrew?
Yes, we do have quite a few questions in the chat, in the Q&A. So first one, how do we research an idea to see if it is a patent or a trade, and if it's still available? And then what's the best way to pitch the idea without it being stolen?
So to search an idea that you're wondering about, a trademark or a invention that you have, we have our PTRC libraries. We have a couple in Arizona, and we're going to have Emma Stoltenberg actually talk about that in a bit. If I believe that they can help with some of the searching, and kind of help inventors understand how to do that entire search process. We also offer an online course called Path to a Patent. I'll talk about that in a little bit too. And throughout that, there is a search component to help the public understand how to search patents.
Thank you. All right. So for legal fees, someone has been told that it costs over 900,000 to keep the patent viable for 20 years. Is that the case?
We do not get into speculating on how much it may cost. You know, the cost on the USPTO end is not nearly $900,000 to maintain your patent life. Now I cannot speak to what costs may occur on the outside, what kind of legal costs may occur. You know, if there is an infringement case brought against your patent, you know, or against if you're involved in an infringement case, then costs are going to escalate. And if not, then you know your costs probably won't be as high. But I have no idea where a $900,000 number came from, and that seems fairly excessive to me.
All right, next question. What if someone patents something you've been selling or doing for a period of time? Do you then have to stop selling your product?
You know, if there is a patent filed, again, we have a first inventor to file system. And if someone else files a patent application that covers your technology, you know, it would be a matter of whether that patent filer would choose to enforce that protection or not.
All right, thank you. Let's see. Are there any recommendations on how to find resources for research and development for patents?
Sorry, what was that one?
Sorry, are there any recommendations on how to find resources for research and development for patents?
Unfortunately, we do not have those types of resources that we offer. That's just not something that we offer at the USPTO.
All right, thank you so much for answering some of those questions. We'll get back to the rest of the questions after Andrew's presentation portion.
Thank you.
Hi, everyone. My name is Andrew Moore. I'm an attorney advisor in the Office of Policy and International Affairs at the U.S. Patent and Trademark Office. So thanks to everyone for having me here today, and thanks for showing up for this presentation. So I'm going to talk to you a little bit about copyright basics and considerations for entrepreneurs. So first up, the purpose of copyright. So as Wade mentioned, copyright comes from the Constitution, Article 1, Section 8, Clause 8, that Congress has the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So what is a copyright? Copyright is a form of legal protection provided to the authors of original works of authorship fixed in a tangible medium of expression. So this includes all sorts of things from music to books, to movies, artwork, photos, TV shows, sculptures, and a number of other forms of creative work such as plays, choreography, architecture, software, and compilations. So you may be asking yourself, why should you care about copyright? Now, there are a number of business assets that can be protectable by copyright. And this includes your advertising and promotional materials, instruction manuals, education materials, software, website, any artistic elements of logos. So it's a little bit different than trademark protection, but artwork, to the extent that it's incorporated into a logo, could be protectable by copyright, as well as the on occasion product design and packaging. It's rarely protected by copyright, but it is possible. So the requirements for copyright protection are a little bit different than they are for other areas of intellectual property. So the first big requirement is that it must be an original work of authorship. So you have to have independently created the work, not copying it from others, and it must exhibit a modicum of creativity. Now, a modicum of creativity is an extremely low level. There isn't any sort of like judging of aesthetic merit when it comes to copyright. So you don't have to have something that's good to be created by protected by copyright. You know, there's no like this is the most creative thing I've ever seen, or you know, it's a very low level. And in terms of independent creation, just refers to you not copying it from other people, but it doesn't necessarily have to be novel in the sense that a patent does. So two people who independently create similar things without having any awareness of each other could both get copyright protection for those things as long as they're not copying from each other. The other big requirement is that to receive copyright protection, the work must be fixed in a tangible form of expression that's perceptible either directly or with the aid of a machine or device. So the example I always like to use for this is if you're writing a song, you have to have either written down the song or recorded yourself singing the song or playing the song or whatever. That receives copyright protection. But if you're just humming a tune to yourself as you walk down the street, something you kind of come up with on the spot, and there's no recording of it, there's no fixation of it, there's no writing it down, you're just humming it, that's not protectable by copyright because it hasn't been fixed. So there are a lot of things that are also not protected by copyright. So first off, things that are not fixed. Titles, names, familiar symbols or designs, mere variations of lettering, and mere listings of ingredients or content. The listings of ingredients or content kind of, I think, gets to the modicum of creativity rule, right? You know, if it's just a list of, you know, to make a cake, you need, you know, flour, sugar, eggs, etc. You know, that's just information. You would need some sort of creative expression in the way that things are described and discussed, and color added to that to get some sort of protection. Individual words and short phrases are also likewise not considered to be creative enough to qualify for copyright protection. Ideas, procedures, concepts, and principles. The idea of something is not copyrightable. It's the particular expression of that idea that is covered. So the idea of painting a penguin is not copyrightable. But if I paint a picture of a penguin, my particular painting is subject to copyright protection. And the last one on here is works of the US government. There are some exceptions to this, but in general, if you are an employer or officer of the US government, anything that you create within the scope of your employment is not subject to copyright protection. So, if the US Patent and Trademark Office, we write a big report on what is subject to copyright protection. That report was created by the US government in its official capacity by USG employees. That's not protected by copyright. One of the exceptions here is stamps. So the artwork on stamps is subject to copyright protection, but most of the stuff is not. Let's see. So I kind of touched on this a second ago, but there's the idea expression dichotomy, which is says that in no cases does copyright protection for an original work extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it's described and explained, illustrated, or embodied in such work. And now, what that's kind of getting to is the sense that, copyright doesn't protect the ideas. Everyone needs to be able to express their ideas, and the copyright protection extends to the specific way in which somebody expresses the idea. Sorry, hold on just a second. All right. What kind of rights does copyright afford? Copyright includes a bundle of exclusive rights. So this includes the right to make copies of work, to prepare derivative works, which a derivative work would be like adapting a book into a movie. The right to distribute copies of a work, the right to publicly display the work, the right to publicly perform literary, musical, dramatic, choreographic works, pantomimes, or audiovisual works, or the right to publicly perform a sound recording via a digital audio transmission. So you'll notice there the public performance right for sound recordings are different than other copyrighted works. So copyright registration. To secure protection for a copyright, you don't need to register the work. Copyright protection is secured automatically upon creation. So the moment you fix your copyrighted work or your work, it has copyright protection. It's automatic. You also don't need to publish it. You don't need to register it. There are certain advantages to registration, which we'll get into later. But the big takeaway is once you make it, it's got copyright protection. There's no need to do anything else. So why register? First off, you register your works with the U.S. Copyright Office, and it puts others on notice of the copyright claim. There are certain advantages afforded to somebody who has copyright registration. So you have to have your copyright registered in order to file a suit in a federal court for works made in the U.S. So it means you can't sue someone in federal court for infringing your copyright if you haven't registered it. It provides prima facie evidence of validity of a copyright and the facts in the certificate. So that means that when you go to court, if you have a copyright registration, you can say, here's my registration, and the court will kind of accept that that's accurate unless the other party has to disprove the facts of the copyright registration. So registration can also be recorded with U.S. Customs and Border Protection, which helps them kind of seize pirated products, at ports. The statutory damages and attorney's fees can be available in litigation if registration is obtained within 3 months after the publication of the work or prior to the infringement of the work. So statutory damages kind of gets into the types of awards you can get in court when someone's infringed your copyright. There's 2 types: actual damages, which is the actual amount of money you've lost from the infringement, and then statutory damages are preset amounts in the Copyright Act that say, even if, regardless of how much economic harm you actually suffered, you can get up to X amount. Registration is also easier to license, or it makes it easier to license your work and collect royalties and enforce other rights outside of court. So it's not super expensive, and it does actually help a lot of things by registering, but you don't have to. So like I said, registration is administered by the U.S. Copyright Office, which is part of the Library of Congress. You can go to copyright.gov, and they accept your registration there. It used to be that it was all paper, then paper and online, and now they're kind of phasing out some of the online some of the paper forms. But if you go to the Copyright Office website, which is copyright.gov, they have tutorials and a lot of information on how to actually submit the copyright registration. So the process entails filing an application, paying a filing fee, which is $45 to $65, depending on what exactly you're filing. There's different group registration fees and whatnot. And you also have to deposit copies of the work with the Copyright Office. So when you submit your application, you have to send them a copyright so they can look at it and know it. And then some of the works that are submitted to the Copyright Office are also selected for collections in the Library of Congress. So if you have a book and you send it to the Library of Congress, it might end up on the shelves in the Library of Congress. So registration doesn't involve a complex examination process. So this is not patent examination where they're doing a really deep dive into it. It's really just they're looking to see, is it copyrightable? Does it satisfy some basic legal requirements? So it's not a super complicated process. only a really small advantage, or sorry, only a small percentage of applications for registration are refused. So copyright notice, you can put a few different forms of notice on. That's the little C with a circle around it, the word copyright, or this abbreviation COPR with the year of publication and the name of the copyright owner. For anything created after March 1st, 1989, notice is not required. It's kind of a thing you can do. It makes the licensing easier. It gives people information about who owns the copyright to a particular work. If you put it in and someone, strips out the copyright notice information, that is a separate violation under the copyright law. It's related to rights management information. But you don't have to do it. It can be helpful, but it's not going to diminish your copyright because you didn't put notice. It's not going to invalidate your copyright because you didn't put a notice on your work. Okay, so like I said, it informs the public that the work is protected by copyright, identifies the copyright owner, shows the year of publication. There's this idea of innocent infringer. It's not really a thing where, there's no intent requirement to copyright infringement. If you infringe someone's copyright, it doesn't really matter if you knew you were infringing copyright. But when it comes to determining the penalties or the damages that you get, if someone argues that they're an innocent infringer, the court might award fewer, less money. So by having a copyright notice, it kind of takes that argument away from people. They can't say they didn't know it was subject to copyright if it's got a copyright notice on it. So the term of copyright protection, in general, works created after January 1st, 1978. It's if it's a real person, a natural person, that would be the life of the author plus 70 years. If the author is not a natural person, so this would be if it's a corporate author or an anonymous author or somebody, that kind of thing, then it would be 95 years from the date of publication or 120 years from creation, whichever expires first. So ownership of a copyright initially vests in the person who conceives of the work and fixes the expression in a tangible medium. So you think it up, you write it down, it's yours. Joint authors, so people who create a work with the intent that it be one inseparable whole of a work. Those joint authors are co-owners of an undivided interest in the copyright and joint works. So you both own. There's two of you. You both own 50%. You both have the right to license the work. You don't have to get permission from the other person to license the work. But you don't have to account for royalties you get back to the other co-owners. There's something called a work made for hire doctrine too, which is says that the employer is generally the owner of the copyright for certain works created within the scope of employment. So if you're at work and your work asks you to create something, your employer owns the copyright in that because you're making it for work within the scope of your employment. There are also special rules that apply to commissioned works, but we're not going to get into that. So copyright infringement and enforcement. Copyright infringement is a violation of any of the exclusive rights to a copyright. So right to distribution or right to reproduction. Reproduction is a really easy one to kind of conceptualize. If I write a book and you take my book and you make new copies of it without authorization, that's infringement. So the elements of a copyright infringement case that you must prove would be the validity and ownership of a copyright. So you have to prove that you have a copyright and that you are the owner. And you also have to prove that the alleged infringer or a violation by the alleged infringer of at least one of the copyright holder's exclusive rights. So just looking at the validity and ownership of a copyright, this really demonstrates the importance of copyright registration. Because if you have a copyright registration, you've already checked that box. You don't need to provide other evidence that you are that the copyright's valid and that you're the owner of it. You have a piece of paper from the Copyright Office that says you've registered your work, you're the owner of it, it's subject to copyright. And unless the defendant can like prove that that's invalid for some reason, you've checked the box one there. There's a couple different types of liability for infringement. So first off, you've got direct liability. Direct liability would be the party that actually commits the infringing act. So going back to the copies of a book thing, if you are the one making copies of the book without authorization, you're directly liable. Secondary liability involves other parties kind of involved in the infringement, but not actually committing the infringement themselves. So contributory liability is for parties that know or have reason to know of the infringement, and making material contributions to or inducement of the infringing conduct. So you know about it and you're helping it happen. That's contributory liability. Vicarious liability is where you have a right and ability to control the infringing activities, and a direct financial interest in such activities. So there are several limitations and exceptions to copyright infringement. One being the first sale doctrine, which is once you've sold a particular copy of a book, once a right holder has sold a particular copy of a work, the person who owns that particular copy can then resell it or destroy it or rent it out to people, lend it to people. Once it's been sold once, the right holder has no control over that specific copy. There's other special exceptions for libraries, archives, and teaching, some statutory licenses, other TV and radio exceptions, reproduction for persons with disabilities, and a single software copy for archival purposes. The big one, though, is fair use, which I'm sure a lot of you have already heard of. This allows the public to make a reasonable use of copyrighted material under certain circumstances without the copyright holder's consent or royalty payment. And it's for use for purposes such as comment or criticism, news reporting, teaching, scholarship, or research. It's a very flexible exception. It's very case by case. There's no bright line rule, but the courts weigh these 4 statutory factors. So one is the purpose and character of the use, including whether it's commercial or nonprofit. Second is the nature of the copyrighted work. The use of very factual copyrighted works is more likely to be fair use than something that's highly creative. The amount and substantiality of the portion used in relation to the copyrighted work as a whole, the use of a little part of a work, a little unimportant part in particular, is more likely to be fair use than using the entire thing. There is no bright line rule about how much is too much. Sometimes you see people saying that you can use up to 4 seconds of a song and it's fair use, and that's not true. That's just made up. The last one is the effect of the use on the potential market for or value of the copyrighted work. So essentially, is the second use that's at question here, is it replacing, is it causing market harm to the original work? Is it replacing it in the market? Let's see. So copyright infringement remedies, we kind of touched on actual versus statutory damages already. So you could also get injunctions, which is where the court orders the infringing party to stop doing it or to, take a specific action. The court can order the seizure of infringing copies, the destruction of infringing copies and the machines and equipment used to produce them, and attorney's fees and costs. Oops, I'm going the wrong way. All right. The Case Act in 2020 is a kind of new development that basically establishes a small claims court within the U.S. Copyright Office called the Copyright Claims Board. And it considers claims where up to $30,000 in possible award amounts for infringement. And it can also hear claims for a declaration of non-infringement. So if you want to go to the CCB, you can get them to clarify that what you're doing is not infringing. These CCB decisions are reviewable in both the U.S. Copyright Office and federal courts. And it's a good option for lower lower value infringement issues that might be where federal court might be too expensive to make it worth going. I know I'm cognizant on time, so I'm going to kind of go a little quicker through these last ones. So it's a streamlined procedure. It's totally voluntary. Parties can opt out. It's less expensive than federal courts, so the CCB can be a good option. Let's let's see. All right, protection of copyright in the digital age. There are two treaties from the early 2000s, the White Bill Copyright Treaty and the White Bill Performances and Phonograms Treaty. These were kind of negotiated under the World Intellectual Property Organization, which is part of the United Nations. And the US implemented these through the DMCA, or the Digital Millennium Copyright Act, in 1998. It's got three important obligations, one being the right of making available, and then legal protection for TPMs, which are technological protection measures, and rights management information. I think we're going to see slides on each of these. Okay, so the DMCA, it prohibits the circumvention of technological protection measures. Technological protection measures are technology on copyrighted works that either protect access to the work or protect people against copying the works. So you can think of these as like the technology in an ebook that prevents you from making copies of the ebook and distributing them, or something on like a DVD that keeps you from downloading what's on the DVD. Rights management information refers to information about the copyright holder or the license, or just information about the copyright itself that is embedded in the work. So that can be copyright notice, it can be metadata on digital works. The DMCA says you're not allowed to strip that out. So you can't mess with TPMs, you can't strip out rights management information. And the DMCA also limits remedies for infringement liabilities for certain internet service providers. Let's see. Okay, so the notice and takedown system. This is under Section 512 of the Copyright Act. It's from the DMCA. A lot of you may be familiar with this. So essentially, the DMCA provides limits remedies for infringement liability for certain internet service providers that can meet certain criteria. And under the notice and takedown system, a right holder who feels that their work is being infringed can send a notice, takedown notice to a qualifying service provider. The service provider then has to expeditiously take down the material and notify the user that the takedown notice has been received. The user then has the option to respond, objecting to the takedown, and the ISP has to put the material back up unless notified by the rights holder that a copyright infringement suit has been filed. So this is, if you've heard about copyright takedown notices, that's what this is. All right, now I think we've got a couple resources here. I'm going to skip these common copyright myths just for the sake of time. We've got a bunch of resources here, which we can always share with all you guys, but if anyone has any questions, I would be happy to answer those now. And thank you.
Thank you, Andrew. We do have a few questions. Let me just get to them. All right, we have one. So individual words and short phrases are not protected via copyright, but taglines just do it, for instance, then must be protected via trademark or the R. Is that correct?
Yeah, so short words and phrases used in connection with business can be protected by trademarks, for example, but just do it is not, that's not enough to be sufficiently creative to receive copyright protection, those little short words and phrases.
Thank you. And then do I need to copyright my web page?
Websites and software that's receives copyright protection automatically, assuming it rises to the level of sufficiently creative. Like you can have like a blank website that doesn't receive copyright protection. The registration does have its benefits. We can't provide specific legal advice to particular people on whether or not they should register any specific work, but in general, registration does convey the benefits that we discussed earlier today, and websites and software are eligible for copyright protection.
All right, just in respect out of time, we're only going to ask one more question and then move on after that question. All right, so I write curriculum. If I edit or slightly modify a document, do I need to update the year on the new doc? If so, do I then need to keep the original with the year somewhere?
This kind of sounds like it's talking about copyright notice. Again, it's not, without getting into providing specific legal advice, always suggest you consult an attorney to, provide advice on your specific issues. But yeah, sorry, I think it's a little hard to answer that question because depending on it's a kind of fact specific without seeing the actual specific work, and I don't want to accidentally get into the providing legal advice.
All right, that's fine. Thank you so much, Andrew. So we're gonna move forward and allow Wade to just give us a little bit more USPTO resources.
Yeah, I will move through these fairly quick, and we can hear from Emma here before we take off. All right. So here we have some of our free services. You can see here at the bottom of the page, uspto.gov/free services. We offer a wide range of IP resources, including application assistance, education and training, help appealing or fixing application issues, and other services to support the full spectrum of customers, from pro se or individual independent filers for both patents and trademarks, or all the way up to a entrepreneur or a more seasoned entrepreneur, business advisor, or a patent agent or attorney. There's resources here for everyone. Okay. So here we have our USPTO regional offices. We can see here over on the left is our, in orange is the Western region. Our Western regional office is located in San Jose. And we cover everybody touching the Pacific Ocean, as well as y'all in Arizona and Nevada. Also, I will quickly mention we are adding a new Southeast regional office in Atlanta later this year, as well as a community outreach office in New England. Should hopefully be open by December 31st, 2025. And we're just looking to expand our efforts. Okay, thank you. So we have the next we have our IP identifier. This is a very quick, easy tool to use. You can log in, answer a couple of questions, and it will help you identify which type of IP you have in your business. Okay. So we also have our Inventors Assistance Center, or IAC. It is staffed by former supervisory patent examiners and experienced former primary examiners. They will answer general questions regarding the examination process and policies. They can help answer questions concerning formats and items needed in your patent application. They can assist with filling out some of those forms that will be needed, as well as provide general information concerning patent rules, procedures, drawings, fees, etc. We have our USPTO Pro Bono program. It's a network for independent inventors and small businesses that meet certain financial thresholds to receive free legal assistance in preparing and filing their patent applications. Most of the programs are there to help under-resourced inventors. They can connect the inventor with an attorney that's willing to help. However, keep in mind that the inventor is still responsible for the USPTO fees. So here you can see our pro bono map. As we highlight here in the bottom right, Arizona is covered by the Arizona Public Patent Program. And if you Google for that program, it should come right up. We also have our law school clinics. More than 60 law schools around the country are involved and provide free legal services to the public, including inventors, entrepreneurs, and small businesses. And we finally have our PTRC, or Patent and Trademark Resource Centers. They are a network of libraries, public, state, and academic libraries designated by the USPTO to support the public needs related to IP. We actually have two PTRCs in Arizona. one in Phoenix at the State of Arizona Research Library, and we'll be hearing from Emma Stoltenberg here in just a moment regarding the PTRCs, and she is at the Arizona Research Library. And the other one just recently opened at the Arizona State University Library in Tempe. We're excited to have the ASU Library on board, and now I will pass things over to Emma to give you guys a little more information about the PTRC program.
Hi, everyone. So I'm going to try to go through my slides a little quickly. I know that some of you might have to leave in a second here. Before I start, I just want to say if you do have to leave, we have a website called azlibrary.gov, and there is a big Ask a Question button on that website if you want to contact us. So if you need to leave, just visit our website and you can ask a question. So to introduce myself, my name is Emma Stoltenberg. I am the lead reference librarian and the PTRC representative for the State of Arizona Research Library. So just a little background information on the PTRC program. It's been around for a long time. It's found nationwide, as mentioned earlier. They're just kind of a local resource to help disseminate information about patents and trademarks. And the representatives are trained on the different resources and databases. And if there's any updates to those, we're trained as well. So a little information about our location. We started in 2013, so just a little over a decade ago. And up until about now, we were the only PTRC in Arizona, but we're very excited to add Arizona State University as another location. So how can the Patent and Trademark Resource Center help you? So we can help in a few different ways. We can answer your questions. So while a presentation, is definitely a great resource for getting an understanding of patent and trademarks, and Wade and Andrew did a great job doing that today. There are questions that might be specific to you or just need a little bit of clarification. So we are here for those kind of one-on-one questions that you may need. We also provide demonstration for searches. So we can set up a Zoom meeting with you. If you are nearby, you can also come in person. We're kind of located near the Capitol in downtown Phoenix, if you are familiar with that area. And so we can help you with searches. Usually what we'll do is create a generic search and show you how to use the tools. We don't really want to know kind of what your idea is. I'll explain in a minute. But we'll help you with generic examples and show you the ropes of how to use the patent and trademark searches. The other thing we can do is if you're doing historical research, say on a specific patent or an inventor, you want to know like everything that an inventor has done, we can also help you pull those patents. So if it's not necessarily for a search, we can still help you find specific patents or trademarks if you're interested. And then we can also demonstrate how to do that for yourself as well. Now, two things to keep in mind are we're librarians, we're not lawyers. So what we can do is we can direct you to pro bono services, specifically to Arizona. And we can also send you to some law school clinics at the University of Arizona or ASU. They may help you with your case and can help connect you with a lawyer. Again, a note on lawyers, we can't really recommend anyone specifically, but we can point you to directories where you can make that decision for yourself. The other thing is we are the right place for a lot of your questions, but some things are kind of outside our realm of expertise. So Arizona does offer state level trademark services. So we would send you over to the business services at the Arizona Secretary of State's office. So the PTRC kind of helps more on that federal level, whereas, we can send you to resources specifically within the state of Arizona if that's what you're looking for. And then just some updates to, skipped a slide. We made 2 research guides. These are online, and I think we have links to them. We're going to send out a resource list as well. But we have a patent guide and a trademark guide, and so these guides kind of just provide some basics, an overview of the application, an overview of how to do the research, and again, those local resources and some online resources for you. So you can always review those on your own and then ask us any questions that you have about that. All right. Okay, so patent public search. This was updated in 2022. So now you can use patent public search everywhere. Before that, you had to come into a patent and trademark resource center, but now you can search from home or anywhere that you have an internet connection. So this tool is also online on the USPTO website along with their patent basics. And this just kind of gives you an overview of kind of all the different topics related to patents. And there is also a trademark basics. So the trademark search tool was also updated in 2023. So if you have searched this tool before, they did change some of the features of it. So, again, like still coming to us with any questions you have as things change and as they update. So the trademark search used to be called TESS, or the Trademark Electronic Search System. Now it's just trademark search, which is a little bit easier to say. They also provide a basics page as well. So review those guides, review those basics page. And if you still need help, you can ask us a question through this website. Also, again, as I mentioned earlier, azlibrary.gov, there's a link to this form as well. You'll just fill out your contact information, your questions, and an expert will get back to you. And if it's not something within our realm, we can also direct you to the appropriate resource. So hopefully that clarifies what we can do. And we look forward to helping you. And I'm going to turn it back over to Paula now.
All right. Thank you, Emma, so much, and Andrew and Wade. And to those who have stayed on, we have gone a little bit over time, but there's just so much to know about this whole topic. So hopefully you found it valuable. Let's see, let's just close out. So as you can see, there are a lot of resources available to you through the USPTO and the library and Emma and the services they provide. But if you need some assistance with your business, if you're just starting out, right, or you're in business looking for capital, want to understand your finances better, how do you make that business profitable? The Small Business Development Centers have you covered in that area. If you're interested in small business counseling, very easy to request counseling. We've got the link on the screen there. You go to our SBDC website. You'll fill out a request for counseling form. Depending on where you're located in the state, you'll go to that center and meet with a counselor at that center. And as you can see, we have every county covered. So no matter where you are in Arizona, there's going to be an SBDC center that can help you as well. And then just finally, let's see, we will be sending a copy of the presentation slides along with that resource list that Emma had referenced. And Esmeralda, maybe you just kind of share what they can expect as far as getting a survey. Hopefully you share your feedback with us. We'd love to hear from you as we're planning additional sessions. So Esmeralda, I'll have you close us out with what you're going to be sending to our participants. And thank you everyone again for participating.
Hi, everyone. Thank you for joining us today and staying this long in the presentation. So
You can request counseling on our website, and you can research some future training programs on there as well. But I will be sending you'll be receiving a training survey either today or tomorrow morning. It'll be automated. But if you can send some feedback on today's presentation, we would appreciate it, and it'll help us help you in the future. And you will be receiving today's recording along with the presentation slides and some of the handouts and resources that were provided by today's experts. Thank you all again for joining us today, and I hope you all have a great day. Thank you all.
Thank you all.